One of the reasons the Supreme Court in the UK rendered the UK-Rwanda agreement unlawful was depending on its analysis to the Israel-Rwanda agreement. So it depended on the empirical situation that happened because of the Israel-Rwanda agreement and its consequences to prove that the UK-Rwanda agreement, that Rwanda is unsafe.
Does these African countries that are agreeing change somehow the African perspective?
So I think that it's important, for example, you will work on Uganda and Rwanda. It's important and Libya, and to see if these countries are respecting human rights, are respecting the prohibition of torture, they are respecting in fact the right to a fair trial for the access to jurisdiction for refugees, etc.
It's very timely, very important, and like with many other fields of social science, arts, humanity, especially the law, this field is also dominated by the European perspective. An African perspective is usually not given adequate attention. In this regard, it's very important. It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Raach, for the immense work that you're doing in the GSN, and the Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
Dr. Norman Raach, the founder and convener of the Global South Network, visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas.
I would like to point out that Dr. Raach's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings?
This last question is not so easy, a bit complicated.
The Global South Network provides an important space to share experiences and learn good practices from one another.
Dialogue takes on a particular importance thanks to Global South Network, which allow us to believe in a better world of the rule of law.
Good afternoon, everyone. It's my great pleasure to welcome you all to the 19th seminar in the Phase 5 of the International Interdisciplinary PhD in Progress weekly seminar series organized by the Global South Network. I would like to start the session with some introductions. I'm Dr. Nouman Riayat. I'm a lecturer in law at the Leicester Law School. I'm the founder and chief convener of the Global South Network, and I have been running these sessions since March 2023. My research interests lie within the areas of judicial independence, rule of law, constitutionalism, judicial populism, and judicialization of politics. It's a pleasure to chair today's session, and I look forward to learning about the presenters' research and engaging in the discussion that follows. I'm joined by three discussants from different parts of the world. Dr. Rossella Pulvirenti is the first discussant for today's session. Dr. Pulvirenti holds a PhD in the area of international criminal law and human rights from the University of Nottingham. Dr. Pulvirenti research deals with the rights of witnesses of international crimes, including conflicted related sexual violence. Her research has been published in international peer-reviewed journals like Leiden Journal of International Law and Journal of International Criminal Justice. More recently, she has been involved into researching rights of people seeking asylum with protected characteristics, women, LGBTQI+, children, people with disability. She has submitted several evidence to the British Parliament. Her research has been quoted in several parliamentary reports, and she has also been invited to give oral evidence on this topic. She is also the lead for the Sylvia Pankhurst's Gender and Diversity Network and the lead for impact and external engagement. Dr. Fatma Raach is the second discussant for today's session. Dr. Raach is an associate professor, University Tunis El Manar, and president of the Tunisian Association for International Law. Previously, she was an assistant professor at the University of Gendoba and researcher in migration studies. She was also co-investigator on the Fondazione Campagna di San Paolo research project titled Traces of Mobility, Violence, and Solidarity, Reconceptualizing Cultural Heritage through the Lens of Migration. She is also director of the Strengthening Legal Clinics on Migration. Dr. Cristiano Diorsi is the third discussant for today's session. Dr. Diorsi is a lecturer and senior research fellow at the South African Research Chair in International Law, Faculty of Law, University of Johannesburg. He holds a PhD in International Law from Graduate Institute for International and Development Studies, Geneva. Dr. Diorsi did postdoctoral studies at the University of Michigan Law School. His research interests mainly focus on the legal protection of asylum seekers, refugees, migrants, and internally displaced persons in Africa, on African human rights law, and more broadly on the development of public international law in Africa. Finally, it's my great pleasure to introduce our guest speaker for today's seminar, Ramy Moustafa Abdelhady, who is a PhD candidate, graduate teacher, and administrator of the Human Rights Implementation Center at the University of Bristol. His doctoral research examines the legality of safe third country agreements as tools for externalizing refugee protection in Africa, assessed from an African human rights and refugee law perspective. Beyond his doctoral research, Ramy brings extensive practical experience in criminal justice, human rights, and refugee protection. He served in the Egyptian judiciary for a decade, first as a public prosecutor and later as a chief judge. He has worked with United Nations agencies and the African Union. Today, Ramy will present part of his PhD project titled Safe Third Country Agreements as Tools of Externalisation and African Perspective. He will speak for about 25 to 30 minutes, followed by 5 to 10 minutes of comments from our discussants. If time permits, we will then open the floor for a 15-minute question and answer session with the audience. Ramy, we are delighted to have you with us today. The screen is yours.
In the beginning, I want to thank you so much, Dr. Nouman, for reaching out and for the very kind invitation to be here with you, and of course for the amazing discussant who have been like. Once I knew yesterday that they are my discussants, I was excited. At the same time, I was fearful because I know many of them. We met in person or we already engaged, but they don't know me. We engaged through the literature. So I'm so happy that they will be my discussants today. So at the beginning, the title of my thesis would be Safe Third Country agreements as tools of externalization of refugee protection in African perspective. So I wanted to start by putting my, saying what inspired me at the beginning to do this research at the beginning. So 2.5 years ago, when I was working in the African Commission on Human and People's Rights in the Gambia, and then I heard about the UK-Rwanda agreement. At beginning, I didn't know much about safe third country agreement as safe third country as a concept itself and the agreements that emanate from this concept. But then the UK-Rwanda agreement, when it happened, there has been a lot of fuss, a lot of discussions, either through literature or through policymakers in the global north, but we didn't hear much about it at the beginning in Africa. And I was also assisting the special rapporteur on refugees at this point, Madam Maya Sahli Fadel, and we had a discussion about it. And then we started looking at whether this concept has been dealt with in African literature a lot or not. We didn't find much on the safe third country agreement concept itself being interpreted or being discussed in the African literature. So that's how I started my academic journey, deciding to take this point. So at the beginning, I would start by the idea of discussing my thesis structure. So discussants and attendees would understand what's the structure of my thesis. The first thing that I will be doing the introduction, which will have, of course, my background about the topic, the current situation of safe third country agreements in Africa, and also my methodology and theoretical framework. The second chapter will deal with safe third country agreements as neo-colonial tools. So I will discuss the research question that it will come in the second slide, to what extent safe third country agreements can remind us with older colonial migration practices that happened in Africa, and how they can be used as a tool of control of not only the bodies of the refugees, but also the African countries. The third chapter will be more substantial legal analysis. So I will analyze the safe third country concept itself from an African perspective. I will try to put a criteria of safety. So what actually makes a country safe under the African human rights and refugee law frameworks. The fourth chapter will take it more practical side. So I will look at 4 of the regional and sub-regional African human rights African courts. So I would look at the African Commission at the beginning, and also the African Court, but as well I will look at sub-regional systems. I will look at the East African Court and the West African or the ECOWAS Court. To what extent, I will look at the standing rules, the admissibility criteria, and to what extent those regional and sub-regional mechanisms can be utilized to contest safe third country agreements and larger externalization practices. My fifth chapter will be on state responsibility. So I would look into detail into how to establish state responsibility in the context of safe third country agreements for the sending states, but more on focus also on the receiving state and the intermediary state, or the state in the middle, if there are a transit state, or as they will call them more lately, transit hubs. My last chapter will be applying all of the findings of all my chapters on a 6th chapter, which is the UK-Rwanda agreement. I know the agreement wasn't was blocked at the end, but we will take it. It's worthy taking it as a case study and then applying the findings of my thesis on this agreement. So my research question, my main research question will be, how do safe third country agreements interact with the African human rights and refugee law frameworks, and what are the legal implications of refugee protections of safe third country agreements within the continent? There are some research questions. The first one would be how safe third country agreements evolved as part of broader non-entry policies in Africa. To what extent safe third country agreements can be viewed as neo-colonial tools that employed by former colonial powers to shape African migration policies. The third one would be, how can international law principles such as solidarity, burden sharing, and non-refoulement concerning safe third country agreement can be adequately interpreted under the African system? What are the main similarities between the international refugee law and the African refugee law when assessing the legality of those agreements? Can regional human rights bodies and larger judicial and quasi-judicial bodies in Africa serve as practical legal avenues to contest them? What are the legal elements of state responsibility to identify violations of the receiving and transit and also the sending states? My main methodologies would be at the beginning, for sure, I would be doctoral research. It would go for analyzing literature, international and African literature we have, and legal instruments to assess the legal compatibility of safe third country agreements. The second methodology would be case law analysis. So I will examine, I'm examining already a large body of case law from the four mechanisms I mentioned in order to reach clearer view on the safety, the interpretation of the word safety in safe third country, and also to what extent we can put a criteria for those kinds of agreements. The third one will be qualitative empirical research. So I already began doing interviews. I did around 8 interviews with key actors in the four mechanisms, and I'm still having some interviews to do within this year. And also, during my presentation, I will also mention what I have found out from those interviews and how they can support my analysis throughout the thesis. So at the beginning, why Africa? A simple answer would be why not? But Africa, for me, there are 3 main categories I want to mention of why I'm focusing on Africa. First thing, that externalization is intensifying in Africa. Africa is becoming a testing ground for not only EU externalization policies, but now more lately we have seen the American or the US externalization policies and intensifying of safe third country agreements from the US with many African states, as I will mention later. Africa is not just a destination. We have 1/3 of the refugee population worldwide. We have a very unique African refugee law system under the 69 Convention, which is supported by the African Charter. We have better, different understanding and interpretation of concepts such as solidarity and burden sharing when it comes to refugee protection, which is also very important to highlight when we talk about those agreements. We have a multi-layered human rights system based on as I said, the African Charter, the 69 Convention, and the Maputo Protocol and other regional human rights instruments. The gap, we have a gap of literature when it comes to African human rights system when we go into analyzing those agreements under the African system. Litigation mostly is focused on Europe. We have seen many litigation going into Europe when it happened with the UK-Rwanda agreement in national courts in the UK, or with other agreements in the European Court of Human Rights. African mechanisms remain underused. Now I will talk more on externalization, my understanding of externalization. I'm taking the Refugee Law Initiative and externalization on Declaration on Extension of Asylum, definition of externalization, which is the process of shifting functions that are normally undertaken by a state within its own territory to take place in whole or in part outside of its territory. We have many externalization tools: maritime interception, carrier sanctions, safe third country agreements. Externalization attempts to shift protection obligations elsewhere. The rationale of externalization, I will mention mainly 4 rationales that I'm dealing with in my thesis. The first one is distant creation. Safe third country agreements are by its design aims to create distance between the host state and refugees or asylum seekers or even migrants that are transferred under those agreements. It's part of the larger externalization rationale of meta borders, as Moreno Lax identifies it, that it shifts the borders outward and inward to maximize control over the refugee population and minimize accountability. then this also feeds to the idea of irresponsibilization, that externalization generally and safe third country agreements aims to create two main things, to create responsibility diffusion. So it diffuses responsibility across different actors, the sending and the transit and the receiving states. So it would be much harder to establish causation, and then it would be hard to create attribution and establish state responsibility at the end. Responsibility denial, it becomes a game of pointing fingers. Each state would be pointing finger at the other state, that they are the ones who are responsible for the violations or the breaches of the primary obligations regarding those transferred populations. Fortressing Europe, of course, it's part of the idea of fortressing Europe, which extends the fortress of Europe outwards. And now the fortress of Europe not only extended to North Africa, but it also goes to Mid-Africa and South Africa. So when it comes to the safe third country agreement, the simple definition of safe third country agreement is that it's an arrangement concluded between two or more states through which the sending state sends refugees and migrants to another state that is deemed safe. And of course, the definition of safety is the main problem here. It emanates from two older concepts, which is the country of first asylum concept and the safe country of transit concepts, which originally I track back to the 70s from the Scandinavian countries. That has been progressed, the idea of that you came from a safe country, so you can go back to this country, or you even crossed a safe country you applied to asylum at, or you even crossed other country that you could have applied for asylum there and you didn't. Then now we have the new update, which is safe third country, we can send you to a country you have never been to, or you have never crossed to, you'd have no ties to. We can send you there as long as this country is deemed safe. So one of the arguments that supports the notion of safe third country is that under international law, there is no recognized right to choose the country of asylum. So as long as you are found safety, as long as the country is safe, you cannot complain wherever we send you. So if protection can be sought elsewhere, why don't you go to this place and stay away from our country? I will give very small examples of safe third country agreements here, but there are too many of them, and they are increasing every day. So the first one would be Denmark-Rwanda. So of course, besides the UK-Rwanda agreement, which is needs another full hour to talk about, but here when we talk about Denmark-Rwanda, Denmark initiated a memorandum of understandings with Rwanda in 2021 to establish a safe third country agreement with it. And at this point, the African Union responded, which is one of the rare cases that the African Union itself responds to those kinds of agreements. And it says that the Aliens Act that allowed those kinds of memorandum of understandings externalizes asylum and shifts responsibility from countries like Denmark to countries like Rwanda. So it's not, it shouldn't be understood under the idea of burden sharing under the African Union's perspective. When it comes to the US-Africa agreements, of course, we have Dr. Cristiano here. He wrote an amazing blog post on the latest agreements with Africa, between the US and Africa. So I will just give some examples here. These are some of the, this is like an Excel sheet from the Safe Third Country project that aims to focus on the agreements between the US and other countries, and these are the countries in Africa. We have 13 agreements. Some of them are purely safe third country agreements. Some of them are hybrid agreements. So we have 13 countries so far that the Trump administration has concluded agreements with. Some of them, as we can see, have been published. Some of them are still secretive. Some of them we know that they are in return for financial incentives but others we don't know what's the financial return. We have seen that some African countries, once they concluded those agreements, in the next month they have received financial and military aid from the US, which means that those kinds of aid were conditional upon concluding those kinds of agreements. And this is also, like, I can go in more detail in them, but we have a limited time, so I don't want to focus on each of those agreements because there are too much and too many agreements that are there between the US and African states. So this supports the idea of intensifying, that safe third country agreements have been intensified in Africa in the past couple of years, and this is one of the reasons why I'm focusing on it in my thesis. So first, if we go to the African human rights system, this is part of my third chapter. African human rights, like the African refugee law system, provides wider umbrella of protection to refugees. The first one would be that we have a wider definition of refugee under the 1969 Convention, that this extended definition includes those who are escaping from external aggression, occupation, and events that seriously disturbing public order. The good news is not only the definition, but also the idea that this definition reflects on the protection against refoulement, because non-refoulement also extends by this definition that we can send people not only to places where they will be persecuted, like the definition of non-refoulement under the 1951 Refugee Convention, but also we can send people to places where there is events that disturb public order. Here, as I said, like in Africa, we have different instruments adopted by the Commission that extends even the definition of non-refoulement, like the Robben Island Guidelines, the General Comment Number 3, the Right to Life, and General Comment Number 5, and the Sierra Leonean Refugee Law, the Sierra Leonean Refugees cases in 2004, which adopted or somehow implicitly recognized what we call the constructive refoulement. So under the African system, direct refoulement is prohibited for sure. Indirect refoulement as well. I have identified some cases that dealt with indirect refoulement, but also constructive refoulement, which is the idea of putting refugees in a situation which is worse than the situation they may face in their country of origin, and you push them through putting them in this disastrous situations to go back to their countries, which is what happened in this case. There are a lot of guarantees under the African Charter for sure. I deal in my thesis with each of those safeguards and the definition of them and how we can connect it, those extended definitions, extended interpretations the African Commission had and the African Court had to those principles under the African Charter, and how we can connect and reflect on the idea of safety in safe third country agreements. Solidarity, in my thesis, I claim that solidarity in the African system is different, should be interpreted differently than solidarity from the European perspective. In the African, I have had some incidents. So at the beginning, the 1969 OU Convention, actually, unlike the 51 Convention, did mention a mechanism through which states can show solidarity and share burden. Article 2, subsection subarticle 4 says that where a member state finds difficulty to continue granting asylum to refugees, such member states shall appeal directly to a member states through the Organization of African Unity, which is the African Union now, and such other member states shall, in the spirit of African solidarity and international cooperation, take appropriate measure to lighten the burden of the member state granting asylum. So here, under the 1969 Convention, we have a mechanism which is somehow related to the safe third country agreements, but we have a special mechanism that happens through the spirit of African solidarity in refugee law protection. According to all, I haven't found any incidents in which an African state did this appeal to the African Union. throughout all my interviews, I asked my interviewees if they knew any country that made such an appeal to the African Union. So other countries in Africa would share a burden and take refugees in their territories. None of the interviewees had any idea about it, and some of them actually didn't hear about this article because it has never been used in the African system. According to the interviews and according to my findings, it has never been used before. So that's one of the problems I'm shedding the light on when it comes to solidarity. I got some incidents in which solidarity was raised, and the definition of solidarity was and burden sharing was raised by African states. I'm here giving some examples, like the Commission of 10 on Refugees in 1973 mentioned that African states burden sharing in the concept of refugee protection shouldn't be only limited to financial burden sharing, but also to physical burden sharing, that African states should start accepting refugees to their territories. The OEU Council of Ministers in 1979 urged all OEU member states to consider ways of translating the principle of burden sharing into action by accepting refugees in their countries. And I had also other examples in which the African states have explicitly mentioned that burden sharing when it comes to refugees is mainly should be mainly interpreted of physical burden sharing, not only financial burden sharing, which is different than our European counterparts, which always raise the idea of burden sharing, that you will take some refugees and we will give you financial support or financial aid. This is different than how we understand solidarity in our continent. Also, I raised the idea of the principle of good neighborliness and to what extent those kinds of agreements can actually violate the principle of good neighborliness. You are not only accepting refugees from other European countries while you don't have the capacity to host those refugees, but this also will impact your neighboring countries. As we saw in the Israel-Rwanda agreements, many of the people who were transferred to Rwanda and Uganda from Israel will then have escaped to neighboring countries, which means that you are not only sharing burden with a state which actually doesn't have that amount of burden, but you're also burdening your neighboring countries by more refugees that weren't there to begin with. Okay, I will jump to I know my time is very limited, so I will go to the African Commission. The African Commission, this is part of Chapter 4. I have 4 mechanisms. This is one of them. I'm focusing on the African Commission. I'm focusing on the threefold mandate of the Commission. I'm looking at to what extent the protective mandate of the Commission can be utilized to contest or litigate safe third country agreement for the Commission. The Commission has a very wide standing requirements, so the Commission is very generous when it comes to people, to the categories of people who can litigate before it. The admissibility criteria, especially the exhaustion of local remedies, which stands always as a problem before refugees and migrants. In 2000, the African Commission says that it's affront to common sense to require refugees to return to their countries to exhaust local remedies. And since then, it has been consistent with the idea of we don't require refugees to exhaust local remedies, which can help a lot of refugees to contest safe third country agreements before the African Commission. The Commission depends on a wide range of sources of law, international law, and also it refers to European and inter-American system. Also, it also depends on the African human rights and refugee law frameworks I already mentioned. Another thing is the idea of complementarity with the African Court. So the African Commission and African Court had a wide history of conflict between both of them when it comes to cases submitted from the Commission to the court. But lately, according to my interviews, lately this relationship has progressed a lot. And then now the African Court is expecting a lot of cases to be submitted by the African Commission, which could be very helpful because the African Court, one of the main problems with the African Court, that many states have been withdrawing their declarations. So people can't submit individual complaints or individual cases before the African Court. But this good relationship now with the African Commission would allow people to go to the African Commission, and that the African Commission would represent them before the African Court, which goes around the idea of individual declarations. And now there is a lot of progress with this. The relationship with the UNHCR, there has been a historical relationship between African Commission and UNHCR, but the problem I indicate in my thesis that UNHCR, unlike in the European system and the inter-American system, UNHCR has never litigated before the African Commission. They have never submitted amicus curiae. They have never submitted expert opinions before the African Commission, which is very strange. I have indicated how many, like tens of times, the UNHCR has submitted expert opinions before the European Court, and some incidents they submitted before the Inter-American Court, but they have never submitted before the the African Commission or the African Court. And in one of my interviews, it was mentioned that UNHCR is playing it strategically to the idea of which system would be more effective when it comes to litigation, and they are organizing their priorities, which also, like for me, I see it as that it doesn't make sense, because if you want to litigate strategically, you have to work on different regional systems and not only advocate or join in promotional activities with the Commission. Protective mandate is there, which is very important, and UNHCR should use it. This is some of the examples of the cases I'm using in my thesis. Of course, there are other tens of cases also, but these are some of the most important cases I've depended on when it comes to collective or mass expulsions of refugees, arbitrary expulsion, and the due process when it comes to transfers between countries, and also, of course, the protection against refoulement. The promotional mandate, as I said, the Commission, besides its protective mandate, it has its promotional mandate, which is not less important than the protective mandate. We have the Special Rapporteur on Refugees, which I focus on a lot in my thesis, and to what extent the Special Rapporteur on Refugees has been, especially in the last few years, has been very vocal about safe third country agreements and externalization practices in Africa, which is very interesting because, as we will see, the Special Rapporteur has issued a lot of studies and guiding principles, which could be very helpful when it comes to litigating safe third country agreements, either before the African Commission or the African Court, or even sub-regional court, because there are many incidents in which the ECOWAS Court and the East African Court have mentioned the literature, the jurisprudence from the African Commission, and also the promotional activities of the African Commission. I will run fast. These are some of the examples of the engagement with externalization from the African Commission. Of course, we have here the African Guiding Principle on the Rights of Migrants, which is one of the key instruments, and Dr. Fatma was one of the people who wrote this guiding principle, which is very important when it comes to interpreting the idea of non-refoulement and externalization. And externalization wasn't mentioned directly, but those principles are very helpful when it comes to interpreting to what extent those agreements fulfill the African framework of human rights and refugee law. These are also some of the examples that the Commission directly engaged with the safe third country concept. The other example, the earlier examples with externalization, these are the latest examples with the agreements itself. So we have here one of the agreements, for instance, the press relief release on September 2025, the Commission said that the Commission is also concerned that migration agreements concluded between African states and European Union and European countries for the purpose of externalization and management of migration, which often have negative impacts on the fundamental rights of migrants and contradict African objectives of free movement. One last thing when it comes to interpretative mandate, this is one of the things I really want to take my thesis to, is that we don't have any advice, there is an underuse of advisory opinions before, especially the African Commission. The African Commission issued one only throughout its whole history. It issued only one advisory opinion, which is not related to refugee protection. The African Court issued some very little advisory opinions. I want, after I finish substantial part of my thesis and before finalizing my project, to take my project to this step, put it on practice, and initiate an advisory opinion before the African Court about the legality of safe third country agreements, and ask the African Court to what extent those agreements align. So the same questions I'm raising in my thesis, I want also to formulate my thesis into an action before the African Court, which is something I have talked with people in some of the organizations in Africa that have standing to apply for advisory opinion before the African Court, and we are still discussing this initiative. I don't know if I have 1 minute or not, but this is my last chapter, the chapter I'm working on now. I'm about to finalize, which talks about state responsibility under safe third country agreements. I'm looking at the sending states, transit state, and receiving state, and then I'm looking at different modes of state responsibility. Jurisdiction triggers. Does the African system recognize the idea of functional jurisdiction and effects-based jurisdiction, unlike the European counterpart lately in SS versus Italy, which rejected the idea of functional jurisdiction and also only depended on effective control. Then I'm looking at direct responsibility, how to establish direct responsibility for each of those 3 categories. Then shared responsibility, derived responsibility for attribution like aiding, assistance, coercion, and direction and control. To what extent African states can claim that they were coerced to get into those kinds of agreements, and those violations were resulted from coercion from the European Union or the United States or other countries. Then I'm looking at the positive obligations and due diligence that should be as a source of state responsibility under the African system. Thank you so much.
Thank you very much. Thank you very much. Excellent presentation. I really enjoyed. It's very timely, very important. And like with many other fields of social science, arts, humanities, especially the law, this field is also dominated by the European perspective. An African perspective is usually not given adequate attention. In this regard, it's very important. So without much ado, allow me to invite our first discussant, Dr. Rossella Pulvirenti. Welcome.
Yes. Thank you very much. Thank you for the invitation. Thank you to the Global South Network, and thank you for Ramy for this very good and excellent presentation. So I have to say that I'm particularly impressed by the research question, by the fact that you have already very clear research question, you have a clear structure of the thesis, and it's very, very clear to the audience that you have done a lot of work. There is like a rich set of data. So I'm sorry if some of the question I might ask might seem to be basic, but I've not read your full thesis. So let me, allow me to ask a few questions. First of all, all, this is just a reflection and not necessarily a question, but I would like to ask you to reflect on the originality of your thesis. I think when your title, when you talk about an African approach, it seems to me that you kind of somehow downplay the originality of your topic and of your approach that can be only like, I don't know, methodological or a perspective. I think what you're doing it's much more than that, and maybe you write that in your thesis, but from an external perspective, I would like you to invite you to reflect more on how you are reshaping a certain concept. For example, you talked about solidarity. Clearly, using the literature and the jurisprudence that you're using, you are reshaping the concept of solidarity. How does this work in practice? This is clearly a sign of originality. At the end, you were talking about this functional jurisdiction model. Clearly, this is another interpretative element that changes the framework and the way people conceive. The same, for example, I don't know if you do that, you can challenge the concept of safety and what to say. So that one is where the originality of your thesis lies. It's not just a perspective, an approach, but is something that is going to be a workable threshold that you can, of course, import. Also because bringing back, some actors that are less studied, like, the African Commission, the African Court, and so on, they shape international law. So all of that enrich the originality of your thesis. So I can see that you've done a lot of work. So my wish for you for the future is, first of all, to clarify that in your thesis or in your next speech. I've got two quick questions on that. And the first question is a bit playing the devil's advocate. So I'm wondering whether you have thought about this, or whether you touch it in your thesis, or whether you're interested. The first point is consent. I understand that some of these African countries, it might be Uganda, it might be Rwanda, they have consent, they express consent with some of the Western countries to receive some of those refugees, so to have some kind of externalization agreement. So my question to you is, according to international law and the treaties bind the parties, so they have willfully agreed to that. Does these African countries that are agreeing change somehow the African perspective? So I think is a tricky point. I've got my own explanation of that, of course. So I don't know if you thought about it or you want to expand it in your thesis. This is the first question. The second question is whether you can talk more about your methodology, because it seems that you have conducted some interviews, but I think we didn't have much time to discuss that. The question is, how did you choose your sample? Who are you talking to? And what can interviews or empirical research can tell us that the doctrinal work cannot tell us, basically. Thank you very much.
Thank you so much, Dr. Rossella. I don't know, that's an amazing reflection. But
okay, so allow me to invite our second discussant, Dr. Fatma Raach. Fatma, over to you, please.
Thank you. Thank you. First of all, I would like to thank you for this invitation and for giving me the occasion to hear to this really very interesting research. I would like to thank Ramy for his effort. Really, it's very interesting work. And I would like also focus on one element. It's true in the global south, the African perspective of externalization. It is not really treated, but fortunately, I have good information for you very soon. In fact, I just finished an article on African perspective on externalization, and it will be published in a special issue, special volume of the Twaler, the third world approaches of international law review very soon. And I analyzed in this work. I did the same thing. I was very I criticized this concept of third world, third safe country, and emphasizes on the African perspective. For your work, really, it's very interesting. I have some comments, and I think it may help you to make the work more. First of all, the concept of third safe country. It's important to analyze this also from an internal perspective. Internal law perspective, because and also to emphasize on the evolution and the appearance of this concept. This concept is a European concept. It appears in the European Union law, so it's a European concept, and the evolution of this concept was related to this in fact, a European perspective of refugee protection, because the objective was to make the European responsibility less important, and in fact to diminish this responsibility. So after that, this concept was applied without any according any importance to the internal law of this country. So I think that it's important. For example, you will work on Uganda and Rwanda. It's important to and Libya, and to see if these countries are respecting human rights, are respecting the prohibition of torture, they are respecting in fact the right to a fair trial, for the access to jurisdiction for refugees, etc. Because in many states the refugees and the asylum seekers are detained, so they physically they can't access to justice, to court. So they are in a really very difficult situation that make them unable to access to the court. So it's important also to analyze this inconsistent of this concept when we apply it to countries that in reality they don't respect any refugees and asylum seekers' right. The second in fact, comment is related to the last resolution of the African Commission of Human Rights, which is very interesting. It was adopted in November 2025, and in this resolution, for the first time, they applied the guiding principles, because the guiding principle, I was really pleased to take part to this, to the reduction and the adoption to this guiding principle. And the guiding principle is really an African perspective of refugee law, because first of all, the definition of refugee, of migrants, is very large, and the obligation of the states are also very clear, and the principle to non-refoulement is very present here. And in this resolution, the African Commission emphasizes on one important element, which is the solidarity. So you can here work more on this concept of solidarity, which is not only ethical principle. It's a legal principle, and it contains, in fact, when we apply it, we have consequences on the state's practice. And the third comment is about the interviewees. I really want to know more about who the person that you interviewed, because it's important also. Here I join my colleague a comment about the sampling. It's important also to represent, to try to have a wide perspective of interviewees, in order to have the position, to know the position of every. I understand that you interviewed Mrs. Maya Sehri. It's very interesting, but I think also it's important to. I'm really interested to know who the participant, identity of these people, in order to be. To know more about, and to be sure that the target group are really very large. Thank you, and good luck.
Thank you so much.
Thank you, Fatma, for excellent contribution. Now allow me to invite our third discussant, Dr. Cristiano Diorsi. Cristiano?
First of all, I would like to join my colleagues for the kind invitation and this also because I know Ramy for a while and I know a bit about his work and I know how much effort he's putting in it, and actually it's a very timely work, and it will be also a very monumental work, I guess, once it's done, because this question of externalization, it's very timely. It's not just something very recent for Africa. Actually, yeah, some of what I want to say was already said by my colleagues before, but I would just like to point out, the fact that this externalization basically has two dimensions, in the sense that one dimension is what African countries do vis-a-vis deported people from overseas country. And another dimension is what African countries, how African countries act vis-a-vis to African, to African nationals coming from other African countries, in the sense that, as also Ramy highlights, the policy of taking people coming from overseas, both African and non-Africans, it dates back more than a decade now, because the first attempt of Israel that also, were successful. It encountered a very was taken very favorable by African countries such as Uganda and Rwanda, that in a way or in another, Rwanda is always implicated in this kind of situation for more than decades now. But another thing is when it comes to take African deported people from African countries to another. And of course, Ramy talked about the concept of solidarity. Actually, I would like to point out, I don't know who you interviewed, but there was an attempt more than a decade ago, maybe 20 years ago, by Benin and Burkina Faso to host, to act as a third country, like to take refugees that were already in other African countries, but other African countries couldn't bear the burden. The problem was that all these refugees that were proposed to move to Benin and Burkina Faso at that time, they refused, because they didn't find, they didn't find conducive for their own life to be moved from an African country to Burkina and Benin, because they couldn't see any future of in them. The more or less is the same situation that Syrians faced when they were sent to Mauritania, and in Mauritania they complained a lot while they were staying there because they couldn't do anything. So I would like, there are not so much material on that, but there is some about this attempt. And moreover, as you probably know, many African countries now, they are really not very available to take African refugees from other countries of Africa. For example, here in South Africa, it was adopted in March, I think, in March, this new white paper on migration and refugeehood. And for example, South Africa will adopt what is already adopted for a long time in the European Union, in the fact that South Africa will refuse to take refugees that already passed through other safe countries. So if, for example, Ethiopians, they, before arriving, landing in South Africa, they will pass through, for example, Uganda, that is considered a safe country. South Africa will refuse to take them. But you can see also the consequences of this kind of policy, because countries that are already overburdened, like Kenya and Uganda, they are considered safe countries. They will be even more overburdened because South Africa will refuse to take refugees coming from Kenya and Uganda. I mean, not originally from Kenya and Uganda, but transiting from Kenya and Uganda. So this is another step forward. What is called African solidarity in the 1969 convention, but that de facto does not exist, at least in the last decades. Although there are exceptions, like the same Uganda was praised many times by UNHCR, but everything. I mean, you know that, so I don't need to repeat it. And the last comment I would like to say is also, if you see, for example, talking about these recent cases of deported from the U.S., the fact that they're coming to Africa. Sierra Leone is the last example, but there are in these countries, receiving countries, also movements of lawyers. I'm thinking, for example, what happened in Eswatini. There was recently the Association of Lawyers that they went to court to allow these deported people to see lawyers in order to see if for them remaining in Eswatini is the best solution, or if they would need to repatriate it to their own country, or maybe send back to the US. So also this internal dimension, maybe you can try to explore it a bit, because it's also something that is taking place at the moment. These are my main ideas. They are not even comments. They are my main ideas at the moment. But yeah, in any case, we can discuss further in future about that. Thank you.
Thank you very much, Cristiano, for your excellent contribution.
Yeah.
Ramy, now I invite you to respond to all these comments. I hope you were taking notes. Briefly, you don't need to answer every question, every comment.
I was learning.
Yeah, because it's a PhD in progress. We can understand. It's a journey. So whatever you can, entirely up to you. But briefly, please, over to you.
Yeah, I want to thank, of course, Dr. Rossella and Dr. Fatma and Dr. Cristiano for sure for their amazing comments, and they're so super helpful. Like I was taking notes of everything, even the comments and the questions, so I can reflect on them later on. I'm sure that many of them will be very helpful to me in my journey. So at the beginning with Dr. Rossella, the idea of consent, I'm talking in my thesis that consent doesn't matter when it comes to violating your primary obligations under the African Charter and the African regional framework, refugee regional framework, the 69 Convention, and other regional instruments. The only point consent matters is the idea I'm dealing with of state responsibility. So I'm putting on the idea of coercion under the RCEWA. So to what extent we can consider coercion from the sending state towards the receiving state to conclude those kinds of agreements and accept refugees to be something that could tie the sending state's responsibility towards violations that can happen in the receiving state. And I'm doing a lot of analysis when it comes to the idea of to what extent economic coercion when it comes to tariffs, for instance, in the United States, and when it comes to incentives from the European Union, to what extent those things can be considered coercion or incentives, and what's the difference, and to what extent the sending state could be seen as coercing an African state into those kinds of agreements. The second thing, when it comes to methodology, and when it comes to interviewees, yes, this took me some time in the first year, the idea of how can I choose my interviewees. I had some idea because I worked in the commission, so I had some idea of whom I should interview. Of course, like Dr. Fatma, like I didn't interview Maya. I worked with Maya, like I worked with her directly, but I didn't interview her, and my interviews are confidential. Like I haven't. But when it comes to categories of people I interviewed so far from each of the four mechanisms. So I interviewed legal officers, I interviewed commissioners, judges, and people also with UNHCR in Africa. I interviewed also some former commissioners, like who have been like legal scholars litigating for the African court. These are like the 8 interviews I had so far. But I'm still I want to do more interviews. I want them to be 10 interviews at least. And they are still an ongoing process. It's also a problem when it comes to having no new interviews after what I wrote already, like a substantial part of my thesis. But I'm taking those interviews, and I will be developing what I'm writing accordingly to the new things I may get. I don't know if I will get new perspectives. But from what I got from my interviews, the main thing is that the safe third country agreements is underdeveloped when it comes to its analysis under the African system. And of course, having someone like Dr. Fatma who wrote, and I'm so excited that you already like wrote something about it and it's in the pipeline. So I would be super excited, of course, to read it, because I think that this would be like a precedent. Like that would be the first incident that we have. Someone talks about safe third country agreements in Africa, which would help me so much also when it comes to my thesis and my literature review. You're already in my literature review for sure, like before that article, but this will help me also expand my literature. When it comes to resolution 645, the latest in the resolution, I already had them in my slides, but I didn't have time to present it. But it was in the older version I sent you already. It's super important. I was there in the Gambia when the resolution was adopted, the last session of October, and I was doing some interviews, and then the resolution was adopted. I reflect always on it in my writing, especially when solidarity, because as you said, it mentioned explicitly the idea of South-South cooperation and avoiding asymmetric partnerships with other countries like the EU and the US. And it was the first time, I think, the African Commission mentions actors by their names. So they mentioned the US, they mentioned the European Union, the European. So it was a very bold resolution. And I think this goes like a lot of the main reason behind it, of course, like we're having a bold special rapporteur like Salma Sassi, which is like she's very interested. I spoke to her a lot of times. She's super interesting in the idea of externalization, and of course for having someone like you and the other people, Ian and the other people who worked on the guiding principles, which has been super informative when it comes to externalization, as you said. What else? Yeah, having the national perspective like Rwanda, Libya, and Uganda. Dr. Fatma, when you mentioned like looking at the national perspective, at what extent those countries actually, what's the situation on the ground, like the empirical situation there, and to what extent they protect it. I discussed this with my supervisor at the beginning, but they said that this will take a lot of space. Like if we look at incidents and we will try to, especially like for instance, now we have the US agreements, we have at least 13 agreements. So looking at each of those countries' internal situation and to what extent they are safe or not. So that's why I took my last chapter to focus on the UK-Rwanda agreement. So I will do this with Rwanda. So Rwanda would be my case study. So I will be studying the asylum system of Rwanda, and to what extent it has the capacity actually to host those people, to what extent most of the Rwandan refugees are in camps, and how the new people who will be sent to Rwanda will be hosted, and to what extent this is compatible with my definition of safety. I'm trying to formulate in the thesis. Dr. Cristiano also talked about the initiative of Benin and Burkina Faso. That's an amazing point. Like, I need to look at it. I haven't read about it. But if it's an initiative that was there from Benin and Burkina Faso, it's a bit different than the idea of appealing to the African Union under the OAU Convention, that the country which is burdened already to appeal, asking for other countries to share the burden of refugees. So it's a reverse idea, that countries are the ones who initiated the idea of hosting refugees. So I need to look at it as well, like to see to what extent this flipped initiative can work in my context. Recent cases, the Excel sheet I presented also had the idea of which country we have national litigation against those third country agreements from the US, like which country has its national lawyers already contested the US agreement, which is like very few of them. But of course, as he said, like it's very important to look at those national litigation and to what extent it can feed into the African system. I hope I covered many of the points, and that my answer made sense. And of course, I would be so interested to get like further feedback from you.
Yeah, sure. Okay, great. Thank you, Ramy, for your response. Very comprehensive response. Although we have run out of time, and there is no time at all even for the question and answer session, but I can see Cristiano has raised his hand, so we can pick up one question. Please be brief. Over to you, Cristiano.
No, it's not even a question. I was just wondering, as Ramy is focusing the last chapter on the one chapter on the Rwanda UK agreement, I was just wondering if it's not worth the effort to also to focus on the Israel-Rwanda agreement that was successful, and you know, at least can compare a successful agreement with a non-successful one that saw at the center of the agreement the same country, just to. But it's just an idea. Of course, I don't know in terms of space if you will have the space or not. But just, you know, as I mentioned, Rwanda is involved in this kind of agreement for a long time now. If it was a comparison between the two agreements, it was worth it to do that. That's it. Thank you.
Yes, Dr. Cristiano. Thank you so much for this recommendation. And of course, I would love to do it. And I think I will have to do it anyways, because one of the reasons the Supreme Court in the UK rendered the UK-Rwanda agreement unlawful was depending on its analysis to the Israel-Rwanda agreement. So it depended on the empirical situation that happened because of the Israel-Rwanda agreement and its consequences to prove that the UK-Rwanda agreement, that Rwanda is unsafe to receive refugees from the UK, and therefore the agreement would be unlawful. So I think I would have to deal with it at a certain point. But yeah, that's a very important observation. Thank you so much.
Thank you. Thank you very much. Thank you, Ramy, for your excellent presentation on a very important topic. I think it's I must say that it definitely contributes to the wider literature on externalization and the safe third country agreements. Thank you, Dr. Rossella, Dr. Fatma, Dr. Cristiano, for your comments, and most importantly, for accepting the invitation or short notices. The Global South Network warmly welcome PhD student candidates from in any area of study from any part of the world to present their project and receive interdisciplinary feedback. Same time next week, let's listen to our next guest speaker. Until then, look after yourself. Have a great weekend.
Thank you, everyone.
Thank you.
Thank you. Goodbye.